The state opposed bail. It argued that Gana is not a suitable bail candidate due to the seriousness of the charges against her. The state further held that she may interfere with witnesses and that her release on bail would spark public outrage.
On the basis thereof, it is a responsible submission by the state that the accused has failed to discharge the honors, that the accused has failed to discharge the honors to prove exceptional circumstances that are present in the application, more so that justify in the interest of justice that release on bail is justified. It is accordingly requested that the application for bail must be dismissed in the circumstances.
Arguing for her release on bail, Gana said her health will deteriorate if she is kept in custody and that she has dependents to care for.
We state this in our affidavit and we rely on it to convince the court the accused is not a flight risk. However, there is no evidence, nor has there been any indication from the state that there is such a fear that the applicant would be a flight risk. In fact, there is further evidence that was led in the affidavit and confirmed by the investigating officer that the applicant herself knew from 2003 that she was under investigation. Not at any stage did she anticipate what would become of her and try and flee.
She knew since when?
At least 2023, Your Worship. Remember, the evidence is that there were raids at her properties in 2023 and then in 2024. So for a period of at least 2 years, she knew. This will tie in to other arguments which will follow.
The case has drawn public interest and a packed court is expected for the ruling on Monday. Abongile Yankees, SABC News, East London.